SJC-11895, Commonwealth v. Danny Vargas.
Good morning, Mr. Cutler.
Good morning, Your Honor. May it please the court?
I'm sure it will please the court, but
I hope so, Your Honor.
I don't expect to get as much time as they did for the last argument, so.
Thank you, Your Honor. Michael Cutler for Danny Vargas, and we ask this court to give us judicial review of a probation revocation action based on this court's consistent support from Cruz through Cran to Canning this spring of broadly interpreting and enforcing the overwhelming popular support for marijuana reform initiatives to protect consumers and debilitated patients from criminal penalty.
Mr. Cutler, how does this work? In this case, the condition of not using marijuana or probably alcohol, I can't remember whether both of them were prohibited during this period of probation, was imposed when he was not a qualifying person, right?
He had not obtained the recommendation, but in fact, he had a pre-existing, clearly debilitating condition, a herniated disc.
I understand that, but I'm saying that he may have had all kinds of conditions, but he agreed as a term of probation to avoid going to prison, where he definitely wouldn't be able to get marijuana or alcohol, I don't think. He agreed. He was not a qualifying person at that time. He agreed to this condition. Is there a problem with that?
Your Honor, he became a qualifying patient when he obtained the medical recommendation. At the probation imposition hearing, he described himself as medicating with marijuana. His lawyer did not pick up on it. His subsequent lawyers.
But what's the problem with imposing that condition on someone who's not a qualifying person?
I do not have an objection to that, Your Honor. However, once he became a qualifying patient, he should have had the benefit of the law, and lawyers who understood the benefit of the law.
So there was already a revocation hearing, and whatever he did at the first time under the old conditions, then subsequently there was isn't that just done? Don't we move on to the next revocation? Isn't that what we're doing? I mean, wasn't there a condition? There are several steps here before you get to another condition where he's told, and not the first hearing, but he's told absolutely don't use marijuana, and then he gets the recommendation for use from a certified physician, right?
He obtained the condition after he obtained the recommendation after his counsel and he had agreed to this condition. That's correct.
So now we're talking about the second hearing.
The hearing that happens after he's got the recommendation.
So now we're in the position where we're now looking at, not the first one, but now isn't it where we're looking at? So what does the referendum require? What's the language of the referendum? And
the language of the referendum is any person meeting the requirements of under this law shall not be punished under Massachusetts law in any manner or denied any right or privilege for such actions.
Correct.
A qualified patient shall not be subject to arrest or prosecution or civil penalty for the medical use of marijuana provided, and I summarize,
But don't you think you can waive that?
Pardon me?
You don't think somebody can waive that knowingly?
Perhaps knowingly, Your Honor, but first of all, we have ineffective assistance here. The counsel says the law doesn't apply because there's no dispensaries open. And secondly, Your Honor, the amicus points out that in Spence versus Reeder, which was recently approved in the Garrity case in 2012, that courts have long refused to give effect to purported waivers of statutory rights where enforcement of the particular waiver would do violence to the public policy underlying the legislative enactment. And the legislative policy is clear that this court has enforced is that there shall be no punishment for lawful use of marijuana under the law.
But he was under a court order not to take any marijuana. Doesn't he have an obligation to go back to the court that imposed that order and say, gee, I've now been authorized for the use of medical marijuana. Could you relieve me of that obligation for this limited purpose?
absolutely right, Your Honor. That was what he should have done. However, his lawyer was telling him that the law didn't apply to him because the dispensaries weren't open. So he was getting ineffective advice, and that's why he was unable to avail himself of the opportunity to come in and adjust the conditions.
Let's assume, I mean, I'm trying to play this out because let's assume he goes back to the court and says, aha, I now have this certificate, whatever it's called, so you need to remove that condition from my probation. The court says, well, the reason I placed you on probation as opposed to sending you to jail for 5 years is because you agreed not to use marijuana. You're now using it, so the understanding which led me to giving you probation in the first place is no longer valid. I'm sending you to jail. Not for using marijuana, but because now you're saying you refuse to comply with the very understanding on which you were given probation.
Your Honor, this is like criminalizing a diabetic for using insulin. He has a...
Not exactly.
He has
Not
he has a debilitating condition. He has a
Suppose it was
herniated disc.
oxycodone and not marijuana.
sorry, Your
Suppose it was oxycodone and not marijuana, and the judge said, you know, we'll give you probation, but you're not to use any prescription drugs.
This gets into the constitutional question, Your Honor, of whether there's a fundamental substantive due process right
to
between
use
a patient and doctor
drugs.
to use
Marijuana?
Right to use a
Marijuana.
drug that is in the order, on the basis on which it was prescribed might be the argument. So isn't there a difference when there's no prescription, which says under federal definitions, this is how you take it, this is how much. Under Massachusetts law, there's only a certified physician who gives it to someone, and we have no indication here that there's a fraud on anybody. That's for regulatory purposes, I take it. It's a recommendation. A recommendation is broader, not more, at least that's an argument. It's broader. Is that your view? Is it a broader thing? So because you don't limit the time, you essentially leave it to the user to say, okay, I've got a bad condition, here you can take marijuana.
Two responses, Your Honor. First of all, these are time-limited recommendations that need to be extended. Second of all, a doctor, while it's a binary decision, you either have permission or you don't have permission, the doctor can give an excess permit with a statement of reasons in writing. And I would also point the court to the condition, the interim probation guidelines for medical marijuana patients that was issued about 3 months after the revocation in this case, which is part of my record, in which they say that if there's a question of abuse, that is something the officer can look at, inquire of the certifying physician, and there can be some process for addressing exactly your concern.
So
Cutler,
was there a
Mr. Cutler?
request? No, go ahead.
Mr. Cutler, I want to step back a minute to the language in the statute, punish, the word punished. I would like you to help me understand how this is punishment. What you normally think of is the statute prohibiting the prosecution of somebody who possesses marijuana when that person has a certificate that allows them to use it for medical purposes. Where is it in the statute that punishment, as the word is used, extends to this situation, which is not really punishment? We're not talking about a criminal prosecution. We're talking about a prosecution to which the defendant has pleaded guilty.
Well, Your Honor, I would suggest that he's been on the street for more than a year by the time he gets revoked without committing any new offenses. He is being told that he can't use a lawful medicine to address a debilitating condition.
I get that. What I'm trying to understand is how punishment extends to the situation that you are talking about.
Your Honor, the statute says, shall not be penalized under Massachusetts law in any manner or denied any right or privilege for such action. So I would suggest it's slightly broader than punishment. And you're interfering with his treating a debilitating condition. I would also say, Your Honor, that what I'm asking this court to do, if I just may finish my thought, Your Honor, what I'm asking this court to do is exactly what the Arizona Supreme Court has done, exactly what the Montana Supreme Court has done in curbing a judge's sentencing authority. I'm sorry, Your Honor.
No, that's okay. I was actually helping you.
But don't you have to,
Isn't it a privilege to be on probation, and isn't it therefore denial of the privilege of probation.
Yes, Your Honor, thank you.
Don't you have to show that counsel, had he raised this argument, would have likely succeeded? And couldn't the judge have said, well, I'm not going to let him do the medical marijuana. There must be some alternative for the condition that the plaintiff has, or that the defendant has. And the judge said, I mean, couldn't the judge very well have said, what are the other alternative medications that could be used besides marijuana?
Well, had there been an evidentiary hearing around this issue with the defense counsel raising the defense under the immunity provision of the law, that might have happened. But
Was there a request for reconsideration
reconsideration of
of the violation of probation?
Your Honor, I filed a motion for new trial to try to flesh out the ineffective assistance here. But you know, getting back to this issue, you're talking about a judge second-guessing a medical judgment. And apart from the constitutional questions, there's also this doctrine, which I did not raise in my
No, I'm not talking about second-guessing. I'm saying, are there alternative medications that could be used besides marijuana?
I would, Your Honor, I have no basis for saying in the record.
In your affidavit in support of the motion for new trial, was there anything from the doctor that said there was no alternative besides the medical marijuana?
There was not, Your Honor, but the law does not require that you exhaust all available
But let me ask you
alternatives before a doctor gives a lawful
You have to show that he
certification.
would have won.
Pardon me, Your Honor?
You have to show that the defense counsel would have won.
I have to show that he would have won, but I'm saying that had he raised the issue, the immunity provision trumps a judge's, it takes away the judge's authority to sanction for lawful medical use.
But he's not punishing him for it.
Well, Your Honor, I would
The
suggest that going from
defendant
the street
advanced
to
the
prison
argument
for
at the
2
time
years
of
is a
sentencing.
punishment.
He's saying that at the time of sentencing, he said, look, I was addicted to marijuana. It clouded my judgment, and the judge bought it.
Your Honor, the fact is that it may have had an impact on his, it may have had an impact, but the impact is highly attenuated on the record of the probation surrender, and he has been, you know, he committed no crimes for the year that pre-trial and after this, before he got revoked. He was educationally compliant. He was going to counseling. He was doing everything that the law, that public safety required of him, and I would just suggest that his to be violated for a use of a lawful medication violates both the immunity provision and is an abuse of discretion.
So I'm just trying to understand the scope of this. If a person today, so the law is well in effect, and I don't remember when the offense was in this case.
The offense occurred, Your Honor, 2 months before the effective date of the law.
So the offense occurs now, and the person, and it's similar facts, and marijuana was a factor in what happened in terms of the robbery or the event that led to the criminal charge. And the person comes in and says, I was addicted and it clouded my judgment, et cetera, et cetera. And the judge says, can the judge say, well, you know, and he says, but I've got a prescription to use this. The judge certainly under the statute can sentence him to jail or prison, and under the marijuana law, you can't use marijuana. I mean, it specifically says, nothing in this statute means you can use this.
In prison, that's
right.
correct.
So the judge could do that, right?
The judge could have.
You couldn't make an argument that somehow that's violating something, either the statute or the Constitution, if the judge says, no, I'm not going to put you on probation because I don't.
Your Honor, I would suggest that if a doctor in the course of exercising professional judgment with a patient says, as a matter of your treatment, you need this particular drug, it could be monitored for location and abuse. And the regulation of the interim regulations of the probation department contemplate exactly that kind of an inquiry. But I would respectfully suggest that either under the immunity provision of the statute or under the constitutional provisions, which I would suggest that this court should avoid by simply imposing the immunity provision as a protection, as a limitation on a judge's sentencing authority, that if you've got a lawful prescription, you can be monitored for abusing a lawful recommendation, you can be monitored for abusing that and creating a risk of harm. But under the facts of this case, he was self-medicating, he was lawful, he committed no new offenses, he was making educational progress, he was going to counseling, he was doing everything that protected public safety, and that the only reason discussed with the revocation judge for his being revoked was his medical use of marijuana. On these facts,
But you still, but
violates
you
the
say he
statute.
couldn't, that's the revocation. I'm just trying to figure out if he could have been sentenced to prison at the get-go because the judge did not think that he should be using marijuana.
I would make the argument, Your Honor, and I do make the argument that as a constitutional provision, that's entering into a protected realm that's between a doctor and a patient, and if it's not creating a risk of harm to public safety, and if it's part of a patient's recovery and therefore his rehabilitation, that it is not something that a judge can impose. This lawful medication cannot be prevented. It can be monitored for abuse, but it cannot be prevented.
Okay, so I said before that I thought you would not get more time, but in fact, I'm going to give you a little more time because I've got a few questions I want to follow up on. So you're essentially saying that a judge may impose a condition of no marijuana, but that condition, for all practical purposes, must be a condition that says no marijuana except with a medical certification.
Yes, Your Honor.
And if there is a violation of probation for the use of marijuana,
I'm sorry, provided it's reasonably related
Right,
based on
okay,
his
let's just-
individualized condition.
which it would be here.
Yes.
Okay, so if there is a violation of probation condition for the use of marijuana, am I correct that it would be the defendant's burden to say, I've got a license for it, I've got a medical certification here?
Affirmative license defense, yes, Your
Okay,
Honor.
and that medical certification, as a matter of law, must be signed by a licensed physician, correct?
Yes, Your Honor.
And it must state that the physician's, that in the physician's professional opinion, the potential benefits of the medical use of marijuana would likely outweigh the health risk for the qualifying patient.
Your Honor, that is a concept that is written into the law, but at the time that this certification was created and given to the defendant, there was no statewide form for the face of that document. There now is a statewide form for the face of that document, and facial discrepancies with that document might undermine the value and protection of that. But I would suggest to you that there was no form, so that what the doctor did in granting this certification was appropriate, and if there's a question about the propriety of that, there's another forum for doing that. And this is what I was alluding to before, the doctrine of primary jurisdiction, where this court in other cases, and I know I haven't raised this in my brief, but under the Everett decision of 2009, it's not waived by a failure to raise this issue, and this talks about judicial interference with the substitution of a court's judgment for another agency's finding, and here in the medical marijuana law, issues of compliance with the law between doctors and patients is subject to either the DPH's supervision or the Board of Registration and Medicine supervision.
Okay, but where does it leave us now? Because the petition uses that language, that it's only a written certification when it so states. That was in the petition. That was what the initiative petition
yes, Your Honor.
declares, but I gather you don't have any document which so states.
The certification is in the record, Your Honor, and if it is deficient with regard to the exact detail of compliance, I don't have it in front of me here. It's certainly purported. We have the patient went in to see this doctor. He was issued a certification under the law. He has a debilitating condition. There's no question but that.
Okay, but I mean, but we can have the same situation if it's, say, oxycodone is the condition. I know we don't have the initiative petition, but judge could say, no oxycodone, you committed this robbery because you were trying to get money for oxycodone. Oxycodone is destroying your life. No oxycodone. Violates because he's using it. He then brings some piece of paper from a doctor.
A prescription, Your Honor.
Okay, is the judge obligated to accept that without it being scrutinized? Does the Commonwealth not have the opportunity to say, Your Honor, this is not from a licensed physician, this is essentially a fraudulent prescription?
Well, if it's a fraudulent prescription, Your Honor, then there are remedies involving the fraudulent prescription law, and there is such a provision under the initiative as well for raising that particular concern. Probation has taken on the authority under the interim guidelines to monitor medical marijuana patients for abuse.
Okay,
of
but
a
this is in the
lawful
context of
certification.
violation of probation hearing. I mean, can the probation say, Your Honor, you should not credit that because that was fraudulently obtained, and therefore he is in violation not only for having used it without a valid prescription, but for having obtained a fraudulent one?
If in fact there is some evidence of fraud, Your Honor, but there's nothing in this record, no admissible evidence at least on this record, that this was a fraudulently obtained document.
Right, but you also don't have a
And it's uncontested that he has a herniated disc, which is clearly a debilitating condition, which would qualify him. I mean, other facts, Your Honor, might raise a different case. My facts, we're certifiable and we are qualified.
Okay, thank you.
Thank you, Your Honor.
Mr. Chief Justice, may it please the court, my name is ADA Phil Mallard. On behalf of the Commonwealth today, I'd like to start off by the points that Justice Hines raised regarding the punishment, and that this defendant was not punished for being a qualifying patient or for using medical marijuana. And that's, I think, the lens through which this entire case should be viewed. I think the points made by Justice Lenk concerning a individual subject to addiction for opiates or other more specific drugs such as oxycodone, heroin, things like that, would pose a circumstance where a judge is under no obligation to suffer a probationer who's committed a violent felony to essentially waive a prescription in the face of the trial court judge during the course of probation and excuse conduct which was the impetus for the violent crime that he committed. This defendant stands in the same position as an individual in that circumstance as well.
But if the probation revocation is based solely on failing the drug tests, no conduct that would, violate the law in any way. And so it's solely about failing the drug tests, and the failing the drug test is solely about marijuana, and he has a prescription to do it. If you revoke probation, that's not punishment?
Well, it would be a recommendation. I think that's critical too, because the distinction between a recommendation and the prescription is critical. But he's not being punished for for being a qualifying patient. He's being punished for violating an order of the court at the time he's placed on probation.
Yeah, but
Could you
it
go
says
back to that?
Shall not be penalized under Massachusetts law in any manner. Is not a revocation of probation to penalize him in some manner?
Well, I think if the court were to look at it that way,
So this is the language of the petition. It's not mine. I didn't make it up.
no, but if the court were to construe the punishment as ensuing from the fact that he is a qualifying patient and the fact that he is subject to this recommendation, I think sort of rearranges the nature of the condition. A person is not punished while they're on probation for committing a new offense. They're punished for violating the order of probation for which they committed.
Put aside the language of punishment. I'm referring to the language of the petition, which speaks about being penalized under Massachusetts law in any manner.
Or denied any right or privilege.
Well, I can tell the court that probation is not a privilege. Probation is an act of grace, and I struggle to find any cases that describe probation as a privilege. This defendant was entitled to be sentenced to state prison.
Okay, but he was on probation before, and then he uses marijuana, and now he's going to prison. Most people would look at that and say that's being penalized.
But not for being a qualifying patient. The qualifying patient isn't the grounds for which he's being penalized. He's being
I'm
penalized.
sorry, but could you go back? Don't quite understand what that point is, but maybe you could clarify for me what you think the difference is between a recommendation and a prescription.
I think a prescription entails some sort of medical necessity and a sort of a federal recognition that this medication is going to be administered in compliance with the terms specified by a prescribing
And what do you
physician.
think a recommendation is, and what's the source of your definition?
The statute.
So what is a recommendation?
It's a certification that medical marijuana may reasonably likely, the benefits may reasonably likely outweigh the possible negative effects.
And they're not otherwise anywhere in the language inhibited to a certain amount, except very broadly. right? So a prescription tells certain dosage amounts times a day, and then it's filled by a pharmacist. Here, it's a recommendation, which is basically, you may use this if you fulfill these conditions, if you have Parkinson's, say, and nothing else will relieves these particular, it's one of those listed things. So the individual has Parkinson's, and this is prescribed. It's a recommendation. And so he gets the marijuana. And you're saying that it's okay for our courts to impose as a condition that marijuana not be used?
I think that this is the situation where if this had come up and this probationer and any other probationer obtains a recommendation and looks to modify the conditions through a hearing before the court, where the judge would be able to exercise his discretion and permit medical marijuana as they permit many other things.
Okay, but let's say it's ineffective assistance for that not to have occurred. So if that were done, you agree that I've lawfully obtained on its face, unless there's a challenge, here's my recommendation from a qualifying physician, says I have a debilitating disease, I am using it in accordance with the recommendations. So I may use it in accordance with the recommendations.
I think that's certainly the first step, and I think the judge's discretion should be informed by a little bit more than just the fact of a piece of paper being issued by a physician. I think the discretion should be informed by the nature of the offense, how closely the offense was related to the nature of, how closely the offense was related to the controlled substance that's now going to be permitted. In the case, this would apply even in the case of a heroin addict and an oxycodone prescription or
Well, let's not talk about illegal substances. Let's talk about legal ones.
Sure.
What if prescribed.
And the nature of the condition, how medical marijuana affects it positively is important, and the availability of various programming while the defendant is on probation, I think are all things that the trial judge, in the exercise of the discretion to permit medical marijuana to be used, should be considered. I had some other things that
Could you just go back to my oxycodone example there? I mean, suppose the condition of probation was, don't use oxycodone, get something else. The guy comes back in and he seeks to modify because he has a prescription for oxycodone and the doctor says that's the best drug for the condition that he has. Does the judge have discretion, are you saying, to still say no in the face of a medical prescription and medical judgment saying that this is the best drug available to treat the medical condition?
I believe the court does, and I think that this happens frequently in drug courts, and perhaps not a complete prohibition, but the judge's discretion to set a complete prohibition on a prescribed medication should be considered thoughtfully and comprehensively with respect to what alternatives are available, the nature of this specific medication in relation to the crime, and the benefits that it has upon the probationer.
So it's fact-dependent. It isn't just the judge can do it if the judge wants to. That's what you're saying.
So I think the discretion should be eminently informed at the time any sort of prohibition such as in Justice Lank's example is set. And I think that's critical here, is that in the second revocation hearing, this defendant faced a variety of bases for which his probation was violated. Not just the testing positive, but in the first one he had a Class B test, and then he also missed a variety of programming and missed drug tests. And the judge...
That led up to the first revocation?
Yeah.
Well,
What about the second?
the second revocation was a variety of missed tests and missed programming once he was placed on OCC Level 3. Now, at the initial hearing, which took place on October 7th, the trial judge stated, look, you got some violations. We can put you, I'm going to hold you without bail for 7 days, and we can come up with some conditions that you can comply with. And I think at that moment, the trial judge was contemplating a situation where the conditions would be modified to any condition that would be reasonably related to the defendant's crime, and also would be a hearing in which the medical marijuana claim would have been adjudicated. And the discretion that I'm discussing here and how that would be informed would be, the record would be built, and the judge could determine whether or not medical marijuana was...
So at this hearing in the fall of 2013, I take it, maybe I'm misunderstanding, the lawyer didn't raise the medical marijuana issue, did he?
on October 7th of 13, the lawyer's advice went out the window because the defendant expressly discounted his advice.
But what Mr. Cutler says is that the lawyer thought at the time that the law wasn't basically in effect because it wasn't operative yet. I mean, there weren't any clinics, there
That
weren't any
was the
dispensaries.
first lawyer, that's Mr. Morris.
But I mean,
The second hearing, October 7th of 13, is Attorney Ranta. And Attorney Ranta, this defendant's facing not just positive tests, and he didn't face positive tests in the first hearing either. But the second hearing with Mr. Ranta, the judge proposes the 7 days, and Mr. Ranta goes outside with the defendant, and they have a discussion, and the defendant doesn't want to put forward any defense. He wants to, as he has previously, make promises about what he is going to do for the court. And I think at this point, there's issues regarding whether any attorney could have advised this defendant otherwise, because Mr. Ranta, as I know, is an extremely experienced advocate who practices frequently in the Superior Court. And Mr. Ranta was keen to put on the record that this defendant was going against his advice, that he advised him to seek to modify these conditions after being held without bail for 7 days, but the defendant didn't want that. The defendant himself made the personal promises to go ahead with the same conditions and go ahead and seek the long continuance during which his compliance would be required, and it would be revisited by the same judge at a later time. I think that's sort of the lens through which the whole case should be viewed, in that this defendant was driving not only the plea, which was conditioned upon him not using marijuana, but the first revocation hearing where the defendant made personal promises there as well, the second in October where he himself went on the record against the advice of counsel, and then also in the last one where the defendant didn't speak because he was sentenced to prison, but which was the product of not just testing positive, but a variety of other bases as well.
But what is the legal significance of that? I mean, going back to Justice Lenck's example of oxycodone, or, you know, a condition of no controlled substances, and the person then has surgery and the doctor gives him morphine for the pain, can you revoke his probation for that?
I don't think any judge would revoke probation for
Not
someone.
would. Can a judge revoke his probation? Would that be an abuse of discretion, or would that to do that?
It would be an abuse of discretion to revoke probation if you're administered morphine in a hospitalized setting post-surgery.
Okay, and that's because you understand that it would be medically necessary.
Yes.
Okay, now, does the statute not essentially say that marijuana may be medically necessary under certain circumstances, and the doctor may so declare?
I don't think medically necessary is anywhere in the statute. It's reasonably likely it may
Medically
have-
appropriate.
I'm not even sure it's appropriate is the term. I think it's may possibly have greater benefits than negative
Okay,
consequences.
But doesn't the statute essentially say we will protect the prescription of marijuana for medical purposes?
And I think that's the real question here. Is this statute, does it create a species of right which far exceed any other constitutional right, the rights of a prescription for any other narcotic? And the defendant believes that, in fact, this piece of paper obtained on one day from a qualifying physician that makes him a qualifying patient creates a set of rights that cannot be infringed upon by any Massachusetts court. And I don't think, based upon the fact that innumerable other constitutional rights can be conditioned, and conditions of probation can be set that infringe upon those rights, such as prior restraint, communications with individuals,
Also,
rights of
may
associations.
I ask you if you think the judge is obligated to consider a certificate? Here, the judge refused to consider anything that the defendant was presenting regarding his condition. Is that your position, that the judge can say, I don't want to hear about your certificate to use marijuana, or is the judge required to look at it and weigh public safety and the defendant's rights to use it?
Well, I was struggling with this question myself, but I think at this point where this defendant obtained his non-incarcerated plea bargain by virtue of promises that he then reneged upon by obtaining the medical marijuana recommendation, I don't think he does. But in a normal circumstance, where it's not so much of a negotiated plea predicated upon this condition, I think the judge's informed discretion should consider the recommendation, and it should consider whether alternatives are available, what this specific recommendation does with respect to programming, how it might disqualify him from things that could be extremely beneficial for him, how his employment may be impacted if he's a truck driver. The recommendation, he shouldn't suffer a recommendation where it's going to make this defendant unemployable. And in the case where he's going to do that, where he is going to sort of look behind the recommendation for its efficacy during the course of probation, he should consider whether the prescribing physician was aware of all the circumstantial and nuanced facts, which the court is, which the probation officer is. And he should be in a position where he's given more information and should be in a position where he's taking it all in and considering what the doctor knew. If the doctor's position is, yes, he's going to be extremely, he's a cancer patient and he's going to receive extensive benefits from this medication, it's going to make his life immeasurably better, then I think that that's a situation where, in fact, he should permit the defendant to use medical marijuana because there's a factual record that supports it. But the fact that a simple piece of paper issued after a one-day visit with a doctor who had never seen this defendant before should not undo months of work with this probationer, a plea to a violent life felony, which he obtained by saying that he wasn't going to smoke marijuana.
Do we know whether the defendant told his probation officer that he was going to seek prescription for medical marijuana?
From my understanding on the record, the probation officer had no idea that this was coming.
I don't see it mentioned anywhere. It's certainly through December, at which point his probation was finally revoked and he was sent to prison.
Correct.
When does this first come up, in connection with the motion for a new trial?
The probation's first made aware of the recommendation, I think, at the sort of the lead up to the first hearing, which took place on August 28th of 13. He had the recommendation, I think it's May 29th is when he gets it.
So probation was aware that he had this?
I think there was a back and forth with the probation officer during that.
I don't see anything in the court proceedings about that.
No, but the officer was aware at the August 28th hearing that he had it. So I think it's a fair inference that this defendant had sort of produced it at some point as an explanation.
And do we know whether or not the doctor knew that the defendant was addicted, had been addicted to marijuana?
If I could just end on that point, I think it would be precisely the circumstance where a prohibition would be justified, is if a probationer was found to be addicted. I think the finding of addiction is a conclusion that this defendant cannot, he's prone to abuse, and he's not in a position where he should have a recommendation, let alone a year-long recommendation. But no, there's no indication that the prescribing physician had any idea about anything that this defendant was facing in terms of his addiction, his substance abuse, the source of this marijuana being the cause of the violent felony or anything of that nature.
Okay, thank you.
No other questions? Thank you.